the chair of this group, but I am going to call us together for today. And then we will, in a little bit, we will be electing the chair and vice chair of this group. But first, to establish quorum, I'm going to ask Don Click to take the roll.
Good morning, everybody. I'll just call out your name. If you could say yes, that would be great. Shane Baker.
You do have to say it vocally. You have to.
I think he's on mute.
Can you unmute?
Try again, yes.
Thank you.
Thank you. Jeremiah Carlson.
Present.
John Donovan.
Present.
Amber Johnson.
Yes.
Morgan Kuntz.
Present.
Kelly Mitchell.
Here.
Mark Osler. Nate Reitz.
Present.
Ken Sass. Robert Stewart.
Yes.
And Ashley Sturts Griffith. And with that, we do have quorum.
All right, excellent. So as you're all aware, we do have to take a vote today, or we do have to elect a chair today. I'm not going to ask for approval of the agenda because I am not the chair. But what I am going to ask for is that we all do introductions before we move to that step. So I also have a colleague who highly believes in icebreakers and has said, has told me that there is research indicating that if you get your voice out into the meeting within the first 15 minutes, it's going to stay out there. And that's what we want with this group. We want people to talk. So I would like to have us go around and tell me, or tell the group, your name, a little bit about yourself, who you represent on this task force. And then our icebreaker question is, what toppings are on your ideal pizza? The folks in the room are looking at me with dagger eyes. I'm just going to say that right now. So I'll start to give you a little time to think about your pizzas, because I've had time. Obviously, I came up with a question. So hi, folks. I am Kelly Mitchell. I am the Assistant Commissioner of Community Services and Reentry for the Department of Corrections. I'm also the chair of the Sentencing Guidelines Commission. On this group, I represent the Department of Corrections. So the Commissioner Schnell, or designee, is one of the members that's supposed to be on this group. So Commissioner Schnell has designated me to fill his spot. So that is the role that I will be playing. And I am actually really boring when it comes to pizza. Like when I want pizza, it's like comfort food, right? It's not like I don't need anything fancy. So I literally just want like pepperoni and mushroom, and like real mushrooms, not the canned ones. So I just want pepperoni and mushroom and light on the sauce, because I'm not like a big sauce person either. So that's me and my pizza. How about if we go around in the room internally, and then I can call on people online. Rob.
Sure. So my name is Rob Stewart. I'm an assistant professor of criminology and criminal justice at the University of Maryland, but I live in Minnesota. It's not ideal. But I'm from here. I did my graduate work here. I went to college at the U and all that. I do a lot of research on sentencing and criminal records and court process and stuff related to that. However, I am representing a person who has been convicted or subject to a mandatory minimum, I guess, because I started going to college while I was in prison 15 years ago. And so that's what started my journey to my PhD. I am also kind of boring, and when I get pizza, I just get pepperoni and maybe pepperoni and bacon if we're going to get a little wild with it. So,
Depends on the mood.
yeah.
Excellent. Nate, would you go next?
Hi, I'm Nate Reitz. I
Who do I represent? That's a good question. So I'm on the task force as the executive director of the Minnesota Sentencing Guidelines Commission. So Kelly is my boss as the chair of the commission. She's also my predecessor. So there's just, you know, she knows
We're
everything
intertwined.
about my job. Let's put it that way. So, but I don't know if I'm tasked to represent the commission. I'm an ex officio member. So, and I probably can't represent the commission because the commission speaks by voting, and they're not. I'm a voting member myself, so I don't have to ask the permission of the commission for every vote I do. So I think I'm just representing myself in my job as leading the staff of the Minnesota Sentencing Guidelines Commission. I'm pretty much like, you know, give me everything on the pizza. I like you know, pretty much just garbage pizza loaded on. Salad bar's fine with me. Just put it in, put some meat in there, and I'll eat it. Our current favorite pizza is Red Savoy's House Special. That's my wife and I's go-to for movie night right now. So it's pretty much got everything in it. I think there is another version. There's like an East Side that has, I don't know, sauerkraut or something. We're not that brave. We go almost all the way, but not quite.
So I'm Morgan Coons. I am the Criminal Division Director at the Hennepin County Attorney's Office. I'm representing one of the county attorney seats on the commission here. Really excited to, task force rather, really excited to work with all of you. I lived in New York for a long time, so I have very strong opinions about pizza. My favorite pizza locally here is Red Wagon in South Minneapolis, and they have one called Popeye, which is spinach and sausage and like a white cheese. It is just phenomenal. They do a really nice job with their crust as well. So highly recommend.
Do you fold it when you eat it or
yes,
not?
you cannot use silverware. You must pick it up, fold it, and, you know, yes. Exactly.
That's a New York thing,
Yes.
right? Yeah.
I'm John Donovan. I'm at the State Appellate Public Defender's Office, and I'm the designee for the State Public Defender. And I actually became a vegetarian about a year ago. So my ideal pizza is just like pepperoni and sausage and all the meats that I don't have anymore. And I would just say, don't take that for granted. Don't say it is boring to just say pepperoni. I dream of it every day. It's all I want. And a crappy hot dog. I just dream of it. So
Nice.
they're not boring.
So,
Don't take it.
so was the vegetarian, was that your choice or is this
That was
like
my
a
choice.
group choice?
No, it was a personal choice that I made that I regret. Every meal, I used to like going out to eat, and now you just find like two things on the menu, and you're like, do I want buttered noodles or an omelet?
Oh, no.
So
Jeremiah Carlson, currently with the Oak County Sheriff's Office. I am representing the Minnesota Sheriff's Association. Currently, I'm a detective in the Major Crimes Division up there. As far as pizza goes with me, I typically would tend to go towards a Meat Lovers pizza. It's kind of one of my personal favorites. Wherever we go there, you got to try them out wherever we go. So
Nice. All right, thank you. So now I'm going to go to the folks online, and I know a couple of you joined us a little bit later. So basically what we're doing is we're saying, just tell us your name, tell us a little bit about yourself, who you represent on this task force, and what is your ideal pizza topping. That is our icebreaker for today. So I'm going to go in the order that I see people, and Amber Johnson. Not hearing you very well.
Any better? I can talk louder.
Yeah, if you get closer, it's a lot better.
Okay.
Yeah.
My name is Amber Johnson. I'm a private criminal defense lawyer in Minneapolis. I represent MACDL, the Minnesota Association of Criminal Defense Lawyers. And my ideal pizza is just sausage. My husband says I'm weird and that nobody ever just orders sausage, but that is what I like.
Excellent. Ashley. Oh, Oh, we went back on mute. There you go.
Can you hear me?
You're off now. Yeah, we can hear you now.
Can you hear
Thanks.
me? Okay. All right. So talking about New York pizza, there's a pizza shop near my house called Elmar's Pizza. I don't know if folks have been there. Well, sorry, let me introduce myself. I'm just like focused on the pizza. All right. I'm Ashley Stewart Griffith. I work at the Minnesota Coalition Against Sexual Assault. We're a statewide organization. We're a membership organization made up mostly of rape crisis centers across the state who are working with victim survivors of sexual assault. And I am the victim services from the member who's from a victim services or victims rights organization. Anyways, back to my pizza. So there's Elmar's Pizza, and I've heard, it's not verified, I haven't actually asked them, but that their water system mimics that of New York. So their pizza crust is actually very similar to like a New York pizza. So I would encourage you all to check it out. I do like the chicken, bacon, ranch. It's the one time I eat bacon. I just love it so much. And they actually like use real like dill on it, and oh, so good. So if you ever get the opportunity, I would suggest that one.
Well, Morgan literally wrote it down, so
Sure did.
he's going to be there. All right, next person is Ken Sass.
Morning, I'm Kevin Sass. I'm the state gang and drug coordinator, which means I work with all the violent crime enforcement teams across the state. So I was named in the legislation as being a part of the committee. I grew up in St. Paul, so my favorite pizza is Savoy. The original is closed, but the other outposts are pretty good, and their sausage is, to me, by far the best.
Excellent. Mark Osler.
Yes, my name's Mark Osler. I'm a former state and federal prosecutor, and I currently teach at St. Thomas. I taught there for 15 years, taught for 10 years before that at Baylor down in Texas. I'm the academic representative. And since I'm from Detroit, I'm partial to Detroit style pizza. And I like pepperoni and spinach buried down in there the way God intended.
Excellent. Shane Baker.
Yes, I'm Shane Baker, Kansas County Attorney. I'm the other County Attorney Association representative. As far as pizza, I probably have the controversial choice because I like a Hawaiian type, so a Canadian bacon, pineapple, and peppers and onions.
All right. Well, thanks everyone. If we ever do lunch, I'll try to bring in all of those pizzas. Probably not. Thanks everyone for indulging me. I really do think it's important to kind of get people talking and get the juices flowing, if for lack of a better word. All right. So next item on the agenda is election of a chair and a vice chair. So under our charge, the committee is supposed to elect its own chair and vice chair. Two people have expressed interest, Morgan and Nate. So I don't know if either of you want to say anything.
Yeah, I can talk. So I put in my application sort of why I was interested in doing this. And I talked with Nate about it. You know, I'm a volunteer. It's how I ended up here. And I just wanted to help out with the management, and I do want to help out. But I also feel like Nate is a really qualified candidate. And so I think we sort of talked, and I would be fine to go to the vice chair position and defer to Nate in the chair position if the task force so agreed.
Nate.
Well, thanks. So I'm Nate Wrights. My previous job before this, so I've been the executive director for about 12 years. My previous job before that, I was a prosecutor for about 15 years for Rice County, mostly felonies, most of that time. This honestly was kind of my burnout job, being the executive director. It was pretty tricky trying to pretend to be ready for 8 to 10 trials every Monday morning. I thought I'd do it forever, but I decided it was time to move on. Prior to that, though, I had been a defense attorney and a prosecutor and really kind of fell in love with criminal law as a defense attorney for the Army, basically a public defender for them, but everybody gets a free lawyer in the Army, basically. So, and I was also a prosecutor in the Army. I stayed on in the reserves, and I was a military judge. So I've kind of done a lot of different roles in the criminal justice system. It's been really interesting to be in this position where I've kind of had a bird's eye view of the state. You know, Rice County, you have a view of Rice County, but you know, you get to see how the whole criminal justice system works together in my position as executive director. So I'm kind of like Morgan. I'm a volunteer. I put my name out there if just in case I could be useful. So if you think I could be useful, I'd be happy to serve in whatever way I could be useful.
All right. Well, so then I kind of have to open it up to the task force, and what are the desires, or does you know, I don't really care how this goes down. I think you both are great candidates, and that's what I would say. I think you both are great candidates, and it would be great to have either of you serving in that role.
I think we could call for nominations from the floor too.
Yep, absolutely. Any thoughts from anyone or nominations? Crickets.
Yeah.
I could move to a vote on it.
Well, I think the question would be, like, are you two comfortable with the arrangement that, like, if Nate was chair and you were vice chair?
I'm comfortable with that, yeah.
That's fine. So just
Okay.
nominate the
So
slate.
I'd like to offer a motion that we as a committee approve Nate as the chair and Morgan as the vice chair. And that's it.
I would second that motion.
Okay.
All right, so we have a motion and a second. Any discussion on the
We
motion?
need leadership. We're a rudderless ship right now.
100%. Any discussion on the motion? Okay, hearing none, I'm going to ask Nate to go ahead and take a vote on that, and then I will defer to whoever is actually defer to the chair after that. Go for it.
All right. Shane Baker,
Aye.
Jeremiah Carlson,
Yes.
John Donovan,
Yes.
Amber Johnson,
Yes. Did you hear me?
Morgan
Yes.
Coo- thank you.
Sorry.
Morgan Coons,
Yes.
Kelly Mitchell,
Yes.
Mark Osler,
Yes.
Nate Wrights,
Yes.
Ken Sass.
Yes.
Was that a yes?
That was a yes.
Thank you. Rob Stewart
Yes.
and Ashley Stewart's Griffith.
You have to unmute.
Thank you.
Great, so congratulations. I think you have officially been elected chair. Don, can I ask one question? I see that Grace is online. Like, was she set for a specific time?
She said she was going to be available from 10:15. So, if we want to go earlier, we can.
So Grace is here from the office of, or to go through the open meeting law things, and Chair Wrights, if it'd be okay with you, it might be good to just go ahead and let her do her little spiel before we move into the meat of the agenda today. That's number 5.
Okay, so let's consider the agenda then to switch 4 and 5. I would also like just an update on membership. Maybe we could have that after the open meeting law. With those changes, is there any objection to the agenda as put forth?
No.
Any objection? Okay, hearing no objection, the agenda is adopted as modified. So let's go to Grace and receive an overview on the open meeting law.
Hello, can everybody hear me?
We can.
Great. All right, I'm just going to get my PowerPoint up here. All right. So my name is Grace Barron, and I'm a policy analyst with the Data Practices Office. We're a small office at the Minnesota Department of Administration, and today I'm going to do a brief overview about the requirements of the open meeting law. Last time I did this presentation, there were no questions at the end, which is fine. You're not required to ask questions, but I was worried it's because I speak a little quickly. So if any questions come up for you while I'm presenting, please feel free to interrupt me and ask them as you think of them. And then, yeah, at the end, I'll also ask for questions. All right, so the open meeting law is found in Minnesota Statutes, Chapter 13D, and it states that all meetings of a public body must be open to the public with limited exceptions, and the public has a right to attend open meetings. The open meeting law itself is a fairly short law, but the Minnesota Supreme Court has stepped in to clarify the requirements of the law from time to time. The Supreme Court has identified.
Yep. Grace, let me just ask you to pause for 1 second. I apologize. While I can see your materials online, they're not showing for us in the room right now. So I'm just want to give Don like a minute to see if he can get them up for us.
Yeah, no problem.
Or do we have them electronic? Do we have hard copies? People have hard copies?
So Grace, I'm not exactly sure what the problem is, but maybe if I actually share them.
Yeah, that's totally fine.
Are these the same slides as Wednesday?
Yes.
Okay, let me go and pull those up, and then if you don't mind, I'll just share them, and that should take care of the problem.
Yeah, that's fine.
Sorry to interrupt. Thanks for being flexible.
No, you're fine.
That's not the right size. And it's still not coming up. There we go. Okay, can everybody see them?
Yes.
Okay, Grace.
Okay. Great, thank you, Don. So the Minnesota Supreme Court has identified 3 primary purposes of the open meeting law. The first is to prohibit actions taken at secret meetings. The second is to assure the public's right to be informed. And the third is to give the public an opportunity to present its views to public bodies. However, the open meeting law does not actually require public bodies to reserve time for public comment, but many public bodies do choose to do so. We can go to the next slide. Okay, so what is a meeting that is subject to the law? Well, the open meeting law does not actually define what a meeting is, but the Minnesota Supreme Court in Moberg versus Independent School District number 281 use the quorum rule to determine when a meeting of a public body is occurring. So there's two parts to this rule to determine when a gathering of a public body is subject to the open meeting law. First, there has to be a quorum, generally a majority or more of the full public body, or a quorum of any of the public bodies, committees or subcommittees, etc. And second, the quorum of members must be discussing, deciding, or receiving information as a group on issues relating to its official business. If you have both of these factors occurring, then you have a meeting that's subject to the open meeting law. So what are some gatherings that would not be subject to the law? Well, if you have a gathering with less than a quorum of your members. An example would be if you had 2 out of 7 board members meeting with a member of the public. 2 is not a quorum, so it's not a meeting subject to the requirements of the open meeting law. Other types of gatherings that are not subject to the law are chance or social gatherings and training or team building activities, so long as business is not discussed. So members need to ensure that they are not discussing matters within the body's official duties or powers at these social gatherings or trainings, as that can change the analysis as to whether the gathering is indeed a meeting. The last bullet point here says to keep in mind public perception. The Data Practices Office responds to questions from government and members of the public on the open meeting law and the Data Practices Act. So we have heard from members of the public who attend an open meeting, and then they see the whole board out to lunch at a restaurant afterwards. As long as the board's not discussing, deciding, or receiving information related to its official duties, that's not a meeting subject to the open meeting law, but you can see how members of the public might think that the board is still discussing official business over lunch. Okay, we can go to the next slide. We have a few other things to be cautious about here. The first is the use of email between public body members. Public body members should avoid discussion of issues relating to their official business over email. In Advisory Opinion 09-020, the Commissioner of Administration found that a public body did not comply with the open meeting law when they exchanged certain email messages relating to their official activities. But the Commissioner noted that one-way communication, such as sending meeting materials to all board members with no discussion or decision-making, would be permissible. Next, the Minnesota Supreme Court in Moberg noted the possibility that serial meetings could violate the open meeting law. Serial meetings are meetings of less than a quorum of the public body that are held with the intent to avoid public meetings to fashion agreement. Whether these meetings violate the open meeting law really depends on the circumstances, and to find a violation, it would need to be clear that the serial meetings were designed to avoid conducting business before the public. Okay, we can go to the next slide. All right, there are 3 types of meetings under the open meeting law. First are regular meetings. These are your regularly scheduled meetings that occur bi-weekly or monthly and are planned out well in advance. The open meeting law requires that you keep a schedule of these meetings on file at your primary office or posted on your website. Next are special meetings, and these are any meeting that's not on your regular schedule. Note that if you have to reschedule a regular meeting, that's going to be considered a special meeting. A notice of a special meeting must be posted on your website 3 days in advance, and the notice needs to include the date, time, place, and meeting purpose. When you calculate the 3 days, you don't count the day of the posting, but you do count the day of the meeting. So if you posted a notice for a special meeting on Friday, you could have this special meeting on Monday and still meet that 3-day requirement. Also note that special meetings are limited to the purpose that's stated in that notice. So the notice needs to state all of the issues that will be addressed or acted upon at the special meeting. Lastly, there are emergency meetings. These involve issues or circumstances that are so pressing that the public body cannot provide that 3-day prior notice. Examples where this comes into play are events like a natural disaster or a health epidemic caused by an accident or a terrorist activity. So in case of emergency members, the public body is required to make a good faith effort to notify media that has requested notice of such meetings. And as you can see, emergency meetings are going to be pretty rare. Next slide, please. Okay, so The open meeting law provides that meetings can only be closed if required or permitted in the law. Minnesota statutes section 13D.05 subdivision 2 sets out when meetings must be closed, and subdivision 3 sets out when meetings may be closed. Note that there's no general personnel exception as a basis to close a meeting. So if you're discussing personnel data or other personnel issues, that cannot be the sole justification to close a meeting. Likewise, the fact that not public data will be discussed at a meeting is not a basis on its own to close a meeting. Minnesota statutes section 13D.05 subdivision 1 states that except as provided in this chapter, meetings may not be closed to discuss data that are not public data. Data that are not public data may be discussed at an open meeting without liability or penalty if the disclosure relates to a matter within the scope of the public body's authority and is reasonably necessary to conduct the business or agenda item before the public body. So what that means is if you need to discuss not public data to do your work, you can do so without liability at the public meeting or at the open meeting. But that provision that exempts you from liability does not require you to disclose not public data at an open meeting. So there are definitely procedures you can put into place if you have concerns about revealing people's identities. For instance, you could use individual 1 instead of using someone's name when you were talking about not public data about a certain individual. If one of the circumstances that are set out in 13D.05 subdivision 2 or 3 are present, meaning that the meeting may or must be closed, then the public body is required to make a statement on the record before closing the meeting. That statement needs to cite the legal authority to close the meeting and specifically describe the subject that will be discussed. So that requirement's helpful because if you're not sure if you can close the meeting or not, it reminds you that you need to go back and look at the statute and find the specific subdivision that applies and be able to cite that on the record before you close your meeting. Lastly, all closed meetings must be recorded, except for meetings that are closed on the basis of attorney-client privilege. And unless otherwise provided by the law, these recordings must be preserved for 3 years after the date of the meeting. Next slide. All right, meetings and technology. This is in section 13D.015. So state level public bodies may hold phone or interactive tech meetings at any time if conditions are met. The first condition is that all members can hear one another in any testimony. The second is that the public can hear discussion, votes, and testimony. The third is that one member of the entity is physically present in the regular meeting room. And the fourth is that votes are taken by roll call so that each member's vote on each issue can be identified and recorded. A little bit about the third requirement. The member of the entity that is required to be physically present in the regular meeting room needs to actually be a member of the board or the task force. It can't be a member of staff. This is in line with the AGO's guidance and a Minnesota Supreme Court case, which held that an ex officio member was not a member of the governing body for purposes of the open meeting law. A few other requirements. The public has to be able to monitor the meeting from a remote site if practicable. This requirement can be met by providing links to watch via computer or providing dial-in information for a conference call, which I know you all have already provided. Additionally, the meeting notice must state that members may participate remotely. The same time and posting methods for regular, special, and emergency meetings apply, but the notice must also be posted on the website 10 days in advance of your regular meetings. Next slide. Okay, records of meetings. The open meeting law does not specifically require preparations of agendas or minutes. However, public bodies must record and maintain votes of their members under section 13D.01 subdivision 4 and Minnesota's Official Records Act, Minnesota Statute section 1517, requires public bodies to make and preserve all records necessary to a full and accurate knowledge of their official activities. So this is often accomplished through the preparation of minutes. Under section 13D.05 subdivision 1, a record of an open meeting, regardless of its form, shall be public. So meeting minutes are public. Also, keep this in mind if you use technology to record or document your meetings. There's no requirement to record open meetings, but if you do so, the recording will become public. So if you are having a meeting and you discuss not public data during an open meeting and you record the meeting, the recording is going to be public. Next slide. All right, penalties and remedies. What happens if there is a violation of the open meeting law? First of all, the Data Practices Office does not find violations of the open meeting law. People can't come to us and have us take action if there's been a violation. Actions on violations of the open meeting law need to go through court. So if the court finds that there's an intentional violation of the open meeting law, the member faces personal liability of a $300 fine. And if 3 separate intentional violations are found, the member forfeits their office. The court can also award reasonable costs, disbursements, and attorney fees. And note that there's no way to reverse actions that the public body took while in violation of the law. That's often a remedy that members of the public would like. They think that an action should be reversed if the group was in violation of the open meeting law, but the law does not actually provide that as a remedy. Next slide. Okay, so that's my brief overview of the open meeting law, and I just wanted to close with a little bit about our office. We're a small office within the Department of Administration, and we provide informal advice and technical assistance to government, public, media, and the legislature. That means you can reach out to us if you have any questions about the open meeting law or the Data Practices Act during your work. We also have many resources available on our website. We have newsletters and YouTube videos on these topics. And we assist the Commissioner of Administration in issuing advisory opinions, and we also provide legislative assistance and training. And Dawn, the next slide just has our contact information. We take requests by phone and email to help people with their questions. So you can reach out to us at any time. And I'll also open it up for questions now if anyone has anything.
Any questions for Grace? Grace, I have a question. So if a body, so there's the quorum issue. If not all the seats of a body are filled, what is the quorum? Is it a majority of the seats or is it a majority of the filled positions?
So unless your enabling legislation defines the quorum otherwise, it's going to be the majority of members needed to like the number of members it would take to take official action. So if you're able to take action with the majority of members who are present, then it would be that majority. If you're not able to act on official matters without the whole body being filled, then I think you would probably have to wait until that time.
Okay, thank you.
Mm-hmm.
Any other questions? All right, thank you very much, Grace. That was very enlightening.
Okay, great.
So-
And yeah, feel free to reach out to our office at any time.
Thanks.
Thank you.
So Don, I did walk in a few minutes late, but I'm wondering if you can just fill us in on the membership. Are all the seats filled?
At this time, we are still 3 positions short.
Okay, so there are 3 vacant seats this time.
Yes.
Don, what are those 3 seats?
We are looking for the peace officer familiar with shootings investigations appointed by the Minnesota Chiefs of Police Association, a member of a statewide civil rights organization appointed by the Speaker of the House of Representatives, and a retired district court judge appointed by the Chief Justice.
Okay. And I know that there are some microphones in the room. For those online, were you able to hear Don's response?
Yes.
What's that?
Yes.
Yes, okay. All right. And is there any work being done to to fill those? Is anybody talking to the appointing authorities?
I am talking to the appointing authorities about every other week.
Okay.
And the House of Representatives, I'm waiting till the beginning of October because they were, with the death of Representative Melissa Hortman, they were delayed in their appointment.
Right. Okay. All right. Okay, thanks for that. So next is Assistant Commissioner Mitchell to talk about the task force's charge.
All right, thanks. And I think Don is going to put up a presentation for me. My name should have been by B as well. So I'll just.
What's that?
My name should have also been next to B, so we'll just roll into that if
Okay.
that's okay with you. There we go. Okay. Perfect. All right. So I just wanted to run us through our charge. I know some folks were able to make it in August, but not everybody that's appointed today was here then. So I wanted to run through it today, and then this is going to bleed into B on the agenda, where I could use some feedback from you to help with one of our next steps. So let's go to the first slide there. So you do also have a copy of the actual statute in your packet. I was just trying to break it down so that you didn't have to read all of that, so that we didn't have to read that together. But really the purpose of this task force is to do three things. We've been tasked with actually collecting and analyzing data on charging, convicting, and sentencing of persons to mandatory minimum sentences. So doing all of that collection, and as we'll see in a minute, data is described in many forms in our legislation. So we're supposed to collect and analyze that data. Through that process, we need to assess whether the current laws and practices promote public safety and equity in sentencing. And then our end goal is to make recommendations to the legislature. So we'll move to the next one. So here's a list of the many types of information, data, quantitative data that we were asked to collect. So we were asked to look at charges, convictions, and sentences that involve mandatory minimums. We were also asked to look at mandatory minimum sentences in which a person received a mitigated durational departure because the mandatory minimum was seen as inappropriate by a judge or county or both, county attorney or both. I'm going to editorialize here. So number one, the statute only calls out durational departures, which means the guidelines call for a prison sentence, but the judge imposes a shorter sentence than called for in the guidelines. I think that they meant to say dispositional departure. At the very least, we should look at both, because dispositional means the guidelines called for a prison sentence and the court imposed a probation sentence instead, or the opposite. The guidelines calls for a probation sentence and the court imposed a prison, but in this case, it would only be the downward one. So I think that we will just automatically expand to include that. And then the other part there, seen as inappropriate by a judge or county attorney, there's no data element that's going to tell us whether they thought the mandatory minimum was inappropriate. But I think what they're getting at is that for some reason or another, the mandatory minimum was not imposed. So I think that's probably the best that we can do there. Third item is mandatory minimum sentences in which a person likely would have received a mitigated durational departure, but for the enforcement of a mandatory minimum sentence. Here again, I think they meant both types of departure and just stated it in artfully. So we'll have to, we'll look to the Sentencing Guidelines Commission for some data on this point. And then the last thing being charges, convictions, and sentences for co-defendants of persons sentenced to a mandatory minimum sentence. Nice aspiration. It'll be, I think, difficult to identify co-defendants, but we'll see. We'll see what we can do. So those are basically the quest is like what, look at actual sentencing practices. I sort of roll that up into look at actual sentencing practices. For a lot of it, I think we'll be asking the Sentencing Commission for data, but they're also asking for charging data. So that means we'll try to attempt to get court data as well, because that's where the charging information is. The next item is that we've been asked to do some legal analysis, review relevant state statutes, state and federal court decisions. I think that Mark Osler is already on it and has started pulling together some information. So I imagine that you'll be tapped for this quite a bit.
And just to be clear, as I understand that, that's looking at what other states have done.
I think that the law did not say that, but I think but that sounds like a good direction to go.
Yeah, just to know what other states. I mean,
Right.
I'll tell you where I'm at right now. I have a student working on this already, and what I asked him to do was to focus on states that within the past several years have undergone a reform review of mandatory minimums.
Excellent. That sounds great. And then you'll want to connect with our chair to talk and our vice chair to talk more about that project and how that could be useful to this task force.
Mm-hmm.
All right, next slide. We've also been tasked with stakeholder input or receiving stakeholder input. And there's 4 specific groups that have been identified to receive input from. So the first one is people who were actually convicted of a crime with a mandatory minimum sentence. Second one is family members of those who were convicted of a crime with a mandatory minimum. The third one is victims, people who were victims of crimes involving the mandatory minimum sentence. And then the fourth one is spreading out again to family members of the victims, people who were victims of crimes with a mandatory minimum sentence. So this one will be returning to in a minute. What I'd like to do is get some feedback from the task force on how we want to go about doing that. The task force was given some funding to do research and outreach. So this is an area where I have procurement laws I have to comply with. So I'd like to get the process going to do that as soon as possible, and I'll be asking for your feedback in our next section here. Okay, next slide. And then assessment. We've been asked to do this assessment. And what the law says is that we have to analyze the benefits and unintended consequences of state statutes and practices relating to the charging, convicting, and sentencing of persons of crimes with mandatory minimum sentences, including whether they promote public safety and properly punish a person for that person's role in an offense. So all of the work that we do should be headed in this direction. All right, next slide. And then from all of that work, our goal is to make recommendations for legislative action on laws that affect the collection and reporting of data and the charging, convicting, and sentencing of persons for crimes with mandatory minimum sentences. So we are collecting data, collecting input, doing some analysis, and making recommendations. That's the main charge of this committee. And then next slide. So our timeline is, we actually have a roomy timeline. Oftentimes these task forces are formed in July or, formed in a legislative session and they're due the next January, but we have all the way till next August But that does not give us a ton of room. It gives us some room. So if you could click forward once more. We were supposed to meet on August 1st, which we theoretically did with not very many members get appointed to the task force. It was just a hi, get to know you kind of meeting. We have to submit our report about it, next year, just 1 month earlier than we are now in the year. And so in the middle there, we have all of the collection analysis, the recommendation drafting. We have to consider, we have, if you want to, we could hold a public hearing. So there's a lot to do in the middle there, and it feels like a roomy timeline, but it's really not, because I think that if we really think about it, we'd have to start having some recommendations really fleshed out by June-ish at the latest, maybe even sooner, in order to meet that timeline next year. So just wanted to give you the big overview of that. Any questions about the charge or anything along those lines?
So do we have a budget for, say, report writing at the end? Okay, so we have a budget for stakeholder engagement and report writing, basically.
We do. And I should mention that the Wilder Foundation is going to come on as a facilitator for this task force. So they will write the report and they will assist with a lot of the activities of the task force. And they will start next month. Any other questions? All right, so with your permission, I'd like to go on to B.
All right.
So we can take that down. So like I said, we do have a budget for some of these things. And the real question that we have to figure out sooner rather than later is the input, the stakeholder input piece. So those 4 groups, people who have been convicted of mandatory minimums plus their families, or people who've been victims of crimes with mandatory minimums and their families. One way some task forces like this receive input is by holding hearings and having people come. Another way to receive input from a task force like this is to have a group to interview people and bring back information. So I should have put that on the agenda as a question, but really what I'm looking for is what sort of one of them requires us to go out and get a group to help us do interviews. Like if we're going to do that, we need to get that process launched now, and we need to identify the group that would do that. If we're going to do hearings, it doesn't take us, that's our job to get it all done. So I'd like feedback from you on the format that you're interested in to get feedback. And then the questions below, I think, will help drive that. So the questions that I'm interested in hearing your feedback on are, what does the task force want to learn from stakeholder input, and how would the input inform your decision making? I'm going to have us do breakouts. So I think we could be one group in this room, and I think, is there just one room enough for one group online, Don?
There are,
Or 2?
I mean, I could break it up if we wanted. There's 1, 2, 3, 4, 5 people online.
That could probably be one.
Got
Yeah.
it.
So we'll do a breakout.
So does that violate the open meeting law? Are they?
No,
They're a sub-quorum, right? So.
They would both be recorded.
Oh, they'd both be recorded.
I think that's recording for them, but then as a separate meeting, it would also record this because the camera's.
WebEx is,
It's below
doesn't
quorum.
record both, but if we come back with a summation of what was discussed and no actual action was taken, that would not break open.
And it's less than a quorum. You're right.
If it's less than a quorum, we're okay. So the members of the public online will be able to hear us or the
We'll be
people.
able to hear this room.
Okay. Well, I think that's fine if they're a sub-quorum, they can meet separately.
All right, what did we say? How much time did we say we were gonna do?
Was that?
How much time did we say we were gonna do?
I think we said 10-15 minutes.
Yeah, so,
So 15.
yeah.
Okay.
Or make it actually 10. Let's do
Make it
10
10.
because we gotta do report outs too.
Sounds good. Second here, and I'll get this. Okay, and I will come back, I'll come back and let everybody know when we've got 1 minute left. So to wrap up.
All right. Okay.
Okay, there we go.
All right, hit me.
So we recently, as you know, Assistant Commissioner Mitchell recently did, well, we're kind of undergoing a comprehensive review of the sentencing guidelines. And for stakeholder engagement, we contracted that out to a state agency. And because it was a state agency, we didn't have to go through a big procurement process. And that's, it's called Management Analysis and Development. It's a subset of Minnesota Management and Budget, which is the state treasury, basically.
So they do not have capacity to do it,
They don't.
but they have a mini solicitation process where they have multiple vendors that have already been approved. And so we can give them parameters for what we're looking for, and they'll put that very quick solicitation out to the vendors that have been approved.
Okay.
And then we can review those and decide who we'd like to work with.
All right.
So in my position as a county attorney, I deal with victims a lot. And I will say some victims are very comfortable talking in an open setting, but a lot actually prefer a one-on-one type interaction, and will often ask us to then read victim impact statements or present them to the court in other manners. And so I think we would probably get more engagement and maybe a little more authentic engagement if it was not in an open meeting. So that would kind of be my thought on that. And I also have some thoughts on some of these other questions, but I can defer to while we discuss the format issue. And I would think it'd be similar with defendants as well, and family members of defendants.
Yeah, that was my thinking, which is why I wanted to broach that question with the group. I just feel like we get more, and I feel like we did interviews with professionals for the commission. I felt like we got pretty good and a more diverse scope of information than when we've done hearings. So
And I don't think we're limited to these groups in our stakeholder engagement either. I mean, I think we could also, I'm thinking of prosecutors, defense attorneys, and judges here, where it's, how does it work for them to deal with mandatory minimums? And
yeah,
are they helpful, not helpful?
That was my thing. I mean, it's interesting that wasn't, I thought that was interesting that wasn't included. Because, I mean, I think it's important to hear from people who are affected and, but it's also important to understand like how this changes the way that prosecutors or defense attorneys or judges, right, think about what they're doing, because it in essence takes away a potential, strategy or line of thinking or whatever. I guess my question is in terms of this first one about what's important to learn from stakeholder input. I mean, I'd be curious to hear what people think about that, just because it's like before deciding whether or not, like this public, I think the public hearing thing maybe isn't the best route as well. But I think it's also helpful to think about who would be best positioned, depending what organization or agency or whatever to collect the data would be best positioned based on what we actually want to know about, right?
I mean, I think a public hearing could have value, and maybe that's one of the things that the contractor, gets from people is, hey, would you be interested in telling your story in public or not? Because I mean, it shouldn't. I definitely agree. A lot of people will not be interested in that at all, but some may, and some may. That at least give us a opportunity for live Q&A, where we could ask them questions. At least that's my thought.
I don't know if it matters at this point when we're just considering it, but there's also going to be a very sizable difference, I think, in the pools here, because so many crimes that have mandatory minimum sentences don't have a victim or a victim's family member, somebody prohibited person in possession of a firearm. There's no victim there. So I think we're going to have a lot more in one pool than the other. I don't know if that's relevant for considering this
More
data,
people have been affected, subject to the mandatory minimum than
Yes.
victims. Yeah.
Mhm.
Is there a way that we could look at, some of the things I think about is oftentimes you run into where these mandatory minimums are coming into play. Typically, this isn't like first time offenses. And especially when we talk about like violent crimes, they usually have a history of that. So is there some victim things we should think about? Are there opportunities for us to talk to those victims that if we are finding these people that maybe have a career criminal jacket and they're getting mandatory minimums, but they have actually some other crimes in there, are those people we could speak to, especially when we talk about like domestic violence and we think about kind of some of the things to learn would be how many times maybe there's a lot of unreported stuff, and that kind of, we're not going to get that stuff in data, but I think it's super important when we think about the criminology of people or over what's happening into those environments.
Yeah, I agree with that, and I think a lot of times the way these prohibited person in possession cases present is it's like an assault 2, which is a 36-month commit, but it's the prohibited person at the 60-month that's driving the negotiations. You see the same thing in domestic violence cases. And so I think while there's no victim in the prohibited person count, a lot of these cases do have victim input implications. So it'll just be important as we identify folks to sort of think about the undercounts, the other counts at play.
Mm-hmm. Yeah.
And I think that's a great example of what Rob was saying was how is this impacting the prosecutors and defense attorneys and their strategies as well.
I mean, because and maybe didn't there used to be if a person was charged with like an assault with strangulation, but then they were not found guilty of that, but then pled guilty to some other element that's on or some other charge in which they'd have to register or something, which would trigger those types of things as well.
So that was, that'd still be a qualifying domestic violence offense. So it would work as an enhancement.
But that wouldn't count as a.
That's not a registrable offense.
No.
But if you had a registrable offense plus a domestic assault, and you pled to the domestic assault, you could still have to register for that if it was arising from the same circumstances and supported by probable cause.
And then the other thing I was sort of thinking about stakeholder input is, I've had some cases that sort of had like a long tail to them or a long, so it's like, my initial discussions with the victim on year 1, and then, we get to a revocation or we get to maybe a resentencing issue 3-4 years later. And there's a really, I've had cases where there's a marked sort of change in the victim's view on things and also I think on the defense side of things too. So I would want to make sure that we get input, not just from people who are like immediately impacted right now, but let's go back and sort of see how people feel about what this whole process was like.
And I think that's where on the kind of a last one that I was on, we had a really hard time engaging victims in some of these things. And I think a lot of times is the perception that I have and my experience in some of those cases. Like I said, I've had some of those long ones where the victims kind of fade in a sense because they're done, right? They've moved past. I don't want to keep talking about it anymore. I'm moving on with my life. And so I think sometimes that's really hard to get them back in to engage on something that they really moved past. So I think some considerations in that too, it's going to be probably more of a struggle to find people to come in and do surveys, or like we said, to do the open, than it would be to say somebody who is impacted, right? That happened to them. So they're going to be more available to talk about their experience.
Right. So then last question, 30 seconds or less. How would input inform decision making, do you think? How do you foresee that happening? Or what role does it play?
So for me, I'm thinking about this in two ways. First, I'm thinking about this, like, okay, this is like an academic answer, but what is the punitive interest of the state when it comes to mandatory minimums and practices? Like, what are we trying to get out of it? Like, what's the utility for the state, right? But then the other part is from the sense of both legitimacy, justice, public safety from the victims and the defendants and the people that work in the system. How are they understanding this process? Is it more of just something to overcome, or something that, or is this something that is meaningful to them? So in terms of the stakeholders, I think that's what I'm more interested in, is understanding whether or not this is a meaningful thing, or if it, I think we place a lot of assumptions sometimes on victims and what they want without hearing about them and what they want, or hearing from them and what they want. Sorry, that was more than 30 seconds.
I think this approach provides us an opportunity as a task force to not be so cold in just statistics, and it'll help shape us the humanity piece of things, which I think is important that we don't lose sight of, right? Like that there's a certain moral code that we as society kind of agree to, and that those types of voices can help make sure that we're in line with some of that stuff, I guess, is what I would look at. Probably the biggest thing to inform decision making of it.
And we're coming back online.
All right. So what did the remote group come up with?
We talked about some of the difficulties with convening these people, for one thing. How to identify them, and just we're talking about how we might want to leverage the victim support people and prosecutors' offices to help with that. Others?
Amber, I think you're muted.
Sorry about that. Ashley had suggested maybe a survey, and that kind of was where could we utilize the victim liaisons and prosecutors' offices for previous cases to reach out to past victims where mandatory minimum sentences were imposed, and maybe we could come up with a survey of questions that we could ask them that we think might address things that we would want to know, or that might inform our decisions or input. I don't know if that's a practical thing to do or not, but you could cast a wider net.
How about our group?
I have an ethical question about that, because one thing I'm concerned about is targeting isn't a great word, but if we go through a liaison type situation and they reach out to people they had worked with in the past, we're kind of imposing a potential re-traumatization on some people. So I'm wondering if there's a strategy, I don't know though. I don't work with victims at all. So I don't know if that's something that, would put people in, I don't know, versus just like a publicizing a recruitment effort type of thing,
Right.
where people can opt in.
I think that's a really good point. And I think we would have to definitely like think about that. Like, you know, and maybe it'd be like their prosecutors' offices, but another thing I was thinking of is like the folks at the DOC who are working with families who the harm doer is incarcerated. Like, if folks, maybe those service providers would like have that relationship and kind of like use judgment in terms of like bringing it up. I mean, I don't know. I feel like there's a lot of different things that we would want to think about. And then like, you know, maybe it's not just giving them a survey. Maybe it's like an advocate would ask the questions. And I guess I was kind of curious about like Wilder, if they had kind of thoughts on how to administer that in a more like victim-friendly way that still gets the information that we could utilize. But yeah, I think it's a really smart question and thing that we'll have to think about for sure.
Well, and I even wonder if they'd be willing to do it in prosecutors' offices. I don't, you know, it's usually, I mean, I think the information sort of comes to them and they respond, but it's not like they usually have a mailing list that they, you know, reach out to victims for.
Yeah, and even if we did dip into our case management system, there's data practices concerns that I would have about using the data that my office has on names and home addresses of victims to then solicit things. So I'd really want to carefully think through the idea of going about it in that way.
I mean, what if we were to leverage like an organization that, you know, and with like an existing mailing list or use their help to recruit people so that we're not just, you know, cold calling people.
Yeah.
Right.
Well, I think that's right. What that kind of being the concern if we're using any sort of in-house victim witness programming, right? I mean, that eventually could also lead to discovery issues, right? Because now the county attorney is asking questions about cases, whether they're current, pending, wherever they're at, we don't know. So I think that's a whole realm of things. I guess I would lean to any time that I've ever tried to drive any data from that sense, I would always like revert back to community victim advocacy groups, right?
Mm-hmm.
Those individuals are typically a lot more charged in getting those impacts out there. And they have a really good tool and resource to be able to get out there, ask questions. You know, they can put out surveys. It gives them an opportunity to also, if it does lead into any sort of re-traumatization, it provides a touch point for them to get back in contact with any services they might need. So I guess if we're looking to try to cast a wide net and just get the data we can through survey stuff, my recommendation would be to lean on those community service-based advocacy programs because there's a lot of protections that help them. They just have those tools.
I would also point out, so we also talked about in this group the possibility of interviews, and those can be anonymous. So that's another potential option. And I think that what we would be doing is basically putting out, on a technical side, I would put a bid out to organizations that could do this kind of work, and they would give us a proposal, and then we would determine what the appropriate group to work with is, and they would have to, if they're doing interviews, they'd have to come up with a recruitment strategy and meet all of those requirements of anonymity and data privacy and those sorts of things. So there are definite barriers. All the barriers that you raised are absolutely correct, that everybody has raised are absolutely correct. But there should be ways to do it.
Yeah, and I would just mention if we are going to use community-based advocacy, that we pay them for their time to do that. It's not like typically their role, but another thing that I wanted to mention regarding that is I do feel like maybe I guess this is like kind of my gut reaction is like how many victims know, like for sure, that the person who caused them harm was facing a mandatory minimum? And I do feel like it's going to also be kind of I would say if you're going to like a rape crisis center and asking them to do that work, I think it's going to be very few people in terms of like sexual violence. I think that is kind of where the prosecutor's office did kind of come in, because there is kind of that, like, we know which of these cases actually fit. But yeah, but I do also feel like there has to be like more of a making it so it's very voluntary, that you're not like, maybe it's like, yes, I guess I'm feeling like every time, like as I'm just talking, I'm just feeling like there's like, oh, what about this? What about this? So yes, there are a lot of challenges, I think, to getting the right group, the appropriate group, into doing it in a victim centered way. And I would like to have a think on it. Thanks, too.
I think those are both really good observations, and I just wanted to lift up that first thing you said about if we are going to be doing this, I do think it's important that we compensate members of the community for this work. I think if we don't, it might bias the data a little bit for folks that are able to participate in something like that and not need the compensation, and we might exclude a large group of folks that are impacted by these cases because of the monetary considerations that would go with something. So I don't know if there's a mechanism to do that within our structure, but I think that will be an important piece of getting input. And then just sort of the second thing you said, I think is a really good thing. And we talked a little bit about this in the room here, that having these conversations with victims and defendants really close in time to the sentence you can get different input than if you go a few years later. And so I think it's going to be important that we have a spectrum of folks giving responses. So some where it's more recent, and then others where this is 5-10 years after the fact.
To the first one, I'm wondering if we can write something into the RFP about that, like through the data collector, as in that would have to be part of what they're paying people or whatever, or compensating, not paying.
Well, I mean, are we in agreement that we'd have to limit it to cases that are resolved and sentenced out?
Yeah,
I think to ongoing, because we wouldn't know necessarily. There are victim impact statements that are requested at every sentencing from probation, and often a prosecutor reads that into the record, or they may appear themselves and give a statement along with family members. I don't know if there's a way to get cases flagged that were mandatory minimums. There's transcripts that could be ordered of the sentencing that would have those victim impact statements in them, if that's public. So it wouldn't be necessarily an issue as to any sort of privacy issues. But that would be one way. And then also maybe seeing where victims did not provide any impact statement or did not respond, just to see how many did and how many didn't in cases.
One thing we discussed was expanding the scope, not just to the statutorily identified groups, but possibly also looking at practitioners, thinking of defense attorneys, prosecutors, and judges. I don't know. It might be tricky to get judges, but.
And just on that, I mean, I live in Woodbury, but I'm from Owatonna, so I mean, I would encourage us to also, if we do that, but not just focus on Hennepin and Ramsey, but also try to, because it's a different world up in northwestern Minnesota and southwestern Minnesota and Duluth and whatever. So I mean, hearing about these different practices and from different people, or from different judges and prosecutors and defense attorneys in these different parts of the state.
Well, I think that's true overall, right? We should be looking. Because it's the low hanging fruit for any of these is you got to go to large counties that have large pools of victim data or whatever. And I think we've got to be intentional about being geographically diverse and diverse in every other way.
And I think that one might even be a little simpler if we have a sort of uniform survey, because between Public Defender's Office, the MACDL, the county attorneys, and the County Attorneys Association, to send it, if we had, a uniform survey, a mass email to people saying, hey, if you've got, the time to actually respond to this, we might necessarily get more responses from the metro counties because there are just more attorneys there. But, we could also have something in there so we know where these responses are coming from as well.
If we can make the judicial survey anonymous, that might help with getting more information. Then retired judges will probably tell us what they think as well.
So I think all of this has to be anonymous. I mean, frankly, I think it may be an all right idea to have a public hearing at some point or whatever, but I think it all has to be like the data collection aspect of it. For me, from a researcher perspective, I think it has to be anonymous because we want to hear what people have to say. Rather than having to tag their name on it. And
I mean, there could be an opt-in option perhaps for people who want to, if you want to be.
What do you want to say on the record? And what do you want to say anonymous?
Yeah, every anonymous survey says, hey, want to say more? Come to this meeting.
Yeah.
Okay. How are we doing on time overall?
10:25. 11:25, sorry.
25, okay.
Yeah, and we do have Senator Latz on the agenda, but it's subject to his court schedule today. So if he gets out in time, he will jump on and we'll just take him wherever. If he doesn't, then we won't have that item today.
Okay. All right. And, one thing I was thinking of is subcommittees and subcommittee chairs. So I've written down data, statutory and case law review, stakeholder input subcommittees. And then I don't think assessment and recommendations is really a subcommittee. I think that's a whole group, product from those three inputs basically, right? Anybody have a different perspective on that?
What were the subcommittees again?
So I've got data, statutory / case law review. I've got Osler written down for that as the chair. I do have chairs written down. And then stakeholder input. So those would be the three subcommittees. And I've got Mitchell written down for two of the chairs. So maybe you could help me figure out which one. Because I think you'd be really good for data or stakeholder input. But I also put just penciling things down here. I'd love to hear input. I put Stewart down for data also, and I put Sturts Griffith down for stakeholder input as an alternate. So I don't know.
Do you want to do data?
Sure. Okay. So does that work? Have Dr. Stewart do data, Professor Osler do statutory / case law review, and by do I just mean lead, and then Mitchell on stakeholder input, and maybe then we can put some kind of survey together to see who wants to be on what subcommittee, Don. And I don't know that it's necessary to have assessments and recommendations at this time, but I know it seems like August 1st of 2026 is forever, but it's faster than you think. So I am glad that the legislature at least gave us a reasonable time period, but that just means we need to move on. We'll be able to get it done. All right. So is this a good time for me to jump in on my memorandum?
100%.
All right. So
You want me to display that for you?
yeah, if it won't work for me to display it. So I tried to catalog all the mandatory minimum prison sentences in Minnesota, and the first page of that document talks about what I'm not calling a mandatory minimum, and I think they're all pretty consistent with our statutory charge. I mean, I don't know. There are mandatory minimum penalties of less than a year. I'm not counting those. There's at least one. I don't know. There may be more than one, but there's at least one mandatory minimum prison sentence that is not required to be executed, which would go to Assistant Commissioner Mitchell's point about duration versus disposition. And I know that gets a little guidelines nerdy, but I'm not counting that one, even though it really meets the definition of a mandatory sentence. It doesn't need to be executed. So that kind of takes the teeth out of it. So basically you have to impose at least a 3-year prison sentence for first degree DWI, but you do not have to execute it. There are mandatory conditional release terms. I'm not counting those. Mandatory consecutive sentences. I'm not counting those. There are statutory guidelines presumptive sentences. So basically it's almost a direction from the legislature to the Sentencing Guidelines Commission to say, here's what the sentencing guidelines have to say. At least that's how the Sentencing Guidelines Commission has interpreted those. I'm not counting those as mandatory minimums, although they're also interesting. And I'm not counting statutes where there's an imprisonment requirement that's contingent on discretionary judicial decisions or determinations. Where there's got to be some analysis of the defendant, being particularly dangerous or being ingrained, or where it's not really automatic or self-executing. There's got to be some judicial discretion involved in the application of those. But one point I want to make about this, and this is the on the other hand paragraph at the bottom of page 1, is that this does include, even though it's called mandatory minimum, you got to understand there are a lot of statutes in Minnesota that call themselves mandatory minimum, or say the court shall impose and execute a sentence of whatever. But then it has an out clause, and we informally call these soft mandatory minimums. I don't use the term hard and soft in this memo because it's not a statutory term, but it is, I think, helpful to think about it that way, where there's a provision that the most common is in 60911, which is the most common mandatory minimum, which we'll get to on the next page. There are provisions where the judge can waive a mandatory minimum if there's a finding of substantial and compelling reasons to do so. Just a side note, that's the same standard basically for deviating from the sentencing guidelines presumption, that the judge finds that there are substantial and compelling reasons for deviating from them. So really, what's the difference between a soft mandatory minimum and just a regular guideline sentence? And the answer is there may not be that much, but it's clear though that the legislature thinks of these as mandatory minimums, and you'll often hear politicians, love politicians, they pay for my salary, but sometimes you'll hear politicians say things like, well, these judges aren't sentencing according to the mandatory minimum. Well, that's because you gave them an opportunity not to sentence according to the mandatory minimum in law. So it's not like the judges are just violating the law. They're using the fact that these mandatory minimums are probably soft mandatory minimums. On the other hand, if there's not an out clause that's provided, then the default is that it's a hard mandatory minimum. So if it just says shall be committed to the commissioner, they shall be committed to the commissioner. So let's look at the chart on the top of page 2. This is really the numbers of cases that fall under the scope of all these mandatory minimums. And if I miss the mandatory minimums, I'm sorry, the figure, the bar chart. So the right on the top of the page 2 there, Don. Let's see. Yeah. So so this chart, and I got to tell you a little bit of little kind of inside baseball on how the Sentencing Guidelines Commission collects data. So we do case level data, and we basically record the most serious charge that defendant got in a month. And so it's possible that you might have a situation where somebody got, your ineligible possession of firearms or ammunition and got a second degree assault. We'd collapse what we consider to be the most serious charge, which carries the most serious penalty. So you see that 3/4 of these sentences, almost 3/4 of the sentences within the scope of a mandatory minimum sentence in 2023, according to our data, were under one statute, and that statute's Minnesota Statute 60911, which ironically, once upon a time, all Minnesota Statute 60911 said is there are no mandatory minimums. And then it's like, except for this and except for this. And now people think of 6911, still says that in the beginning, but it says, but people think of 6911 as the mandatory minimum statute. And for good reason, 3/4 of the mandatory minimums fall under 6911. The next, and the biggest one of those is the inelligibly possessing firearms or ammunition. So there's a separate 5-year penalty for that, where if you're convicted of a crime of violence, something on a list of felony crimes of violence, and at any time for the rest of your life you possess a firearm or ammunition, you're not only guilty of that felony, but you're looking at a 5-year mandatory minimum. The other 6911 makes up the second most highest amount, and then predatory offender registration violation, 300 cases last year. I'm sorry, 2023. We're still working on last year. And then 152 cases, ironically, for Chapter 152 drug related. And then the smallest number is other. I'm going to make a case that just because it's small doesn't mean it's insignificant. So let's look at some of these specifically.
Nate, I just wanted to.
Oh, Senator Latz, we're welcome to the Task Force on Mandatory Minimum Sentencing. The floor is yours.
Good morning. Thank you for letting me jump in here. As many of you know, I'm a criminal defense lawyer, and I just finished in the courtroom. And before I left the courthouse, I want to make sure I logged in to greet you and thank you for your work. What you're doing is important to educate the legislature and guide us in evaluating what, if any, changes ought to be made to our system of criminal sanctions, especially related to mandatory minimums, how they play out, what impact they have, are there any disparate impacts on them, are they effective in achieving the desired ends or the ends that were desired by those who supported them when they were enacted into law, which is, of course, all the pillars of the criminal justice system, deterrence, punishment, and rehabilitation, all of that plays in. And then how well they're all being implemented through the judicial system as well, whether they're appropriate off-ramps and the ones that don't have any off-ramps, the mandatory mandatories and the non-mandatory mandatories, whether they are set up properly as well. So I personally am a bit of a skeptic about mandatory minimums. I'm loath to jump into and undermine the discretion of a sentencing court, especially when we already have a sentencing guidelines in place, which are supposed to provide some modicum of consistency across the state. But that's my personal view and the legislature's intent, and my intent as the author of the legislation was to get a more objective outside evaluation from the experts, those of you who are working day to day in this system. So I appreciate the work that you're doing, and I look forward to receiving your recommendations. If you wish, I'm happy to answer any questions or address anything else you'd like.
Any questions for the senator? Well, thank you, Senator Latz. It's certainly interesting work, and we're looking forward to doing it.
Appreciate that. Look forward to seeing the report. Y'all have a good day.
All right. And I'd just like to point out one thing on this bar chart too, is that the statute gives examples of mandatory minimums, and the examples it gives are basically 3 of those chunks: the 749 in dark blue, the 656 in green, and the 152 in I'll call that brown. So the predatory offender registration was not called out by name, and then nor were the others. But those, as I read this statute, were more examples, including but not limited to the sentencing requirements of 152.021, 152.022, and 609.11. So I think all of these on table 1 are within the scope, but I think that's also something we need to think about, is what is within the scope. And so I'm going to start with table 1. So if you can take us to the top of table 1, Don. There's a column that says statutory authorization to disregard. Those are if it says no, that means it's a hard mandatory. It's what the senator called the mandatory. And basically, what does that mean? Does that mean it's never violated? It does not mean that. What it means is if the prosecutor appeals a sentence that's contrary to that mandatory, the prosecutor is guaranteed to win at the Court of Appeals. The Court of Appeals will side with the prosecutor every time because they've made it very clear if there's no statutory off-ramp for the mandatory minimum, then that is the only legal minimum sentence. So looking at premeditated first-degree murder, we don't think of this really as a mandatory minimum, but it's really quite an extreme mandatory minimum. So the difference between intentional murder and premeditated murder, I'm going to focus on premeditated. And the reason I'm focusing on premeditated is even though this box also covers murders of, say, police officers or murder that resulted from a rape or kidnapping or terrorism, those don't happen very often. Terrorism never happened. The others happen very infrequently. But we always see, I would wager a guess that at least 5 of these 6, if not 6 of these 6, are premeditated first-degree murder. This is a provision that was enacted 20 years ago, which means that in 10 years, the first person who would have been eligible for a probation or parole look will not be eligible for a parole look. Instead, that person will continue to serve a prison sentence for the rest of his life because the normal, at least the current norm, is that you get a look at parole for after 30 years on a life sentence. But these offenses, you do not get a parole look. So there's really 2 mandatories going on here. One is it's a life sentence, and 2 is it's without the possibility of release. So there's really only one legal sentence that can come out of the sentencing hearing is life without the possibility of release. And that's true for the first 3 lines here. But the one that actually experiences cases is premeditated first-degree murder. Just want to point out, though, that the difference between premeditation and intent, so intentional second-degree murder carries a presumptive guideline sentence of approximately between 25 and 35 years, depending on the defendant's criminal history. They serve 2/3 of that, and as long as they've been well behaved, they'll get out at that time and be put on supervised release for the last third. But for premeditated murder, it's again a mandatory life sentence and a mandatory life without the possibility of release, and it's a low number, right? 6 cases is not a large number of cases, but it's a huge impact on those cases, and it's really a significant statement to say that the difference between intending to commit a crime and sort of that extra beat or 2, which is, I think, all the case law requires. Professor Osler, you can correct me if I'm wrong, but it just a little bit of additional time where instead of simply intending to kill, there was actually some forethought and advanced thought about it, and there's enough for premeditation there. That is significant enough that society has legally deemed that it doesn't matter who you are, it doesn't matter what you've done with the rest of your life or what you're going to do with the rest of your life. There's no release for you. You will die in prison. So that's something, again, it's as far as bang for our buck time-wise, it's a very low number, but it certainly has a significant impact.
Just one observation on that.
And that impact is theoretical for the next 10 years, and then it will become real. Yes.
I think there's probably a larger subset of cases where that's charged, but it resolves as something else as well. So I think that number 6, I think your observations are correct. And I think that number 6 is only sentenced cases, it looks like. But I think if we looked at the data, we'd see more cases charged and just resolved in.
Well, and I think the vice chair brings up a very important point, and that is we need to look at mandatory minimums not only for their face value, but also for their plea bargaining value. They can serve as essentially lubricants for the plea bargaining process, if you will, and make a defendant who might be very insistent on going to trial much more amenable to taking a lesser plea. And that may not show up on our data because those are the dogs that didn't bark, because we don't see those mandatory minimums in effect because they were used as leverage. So we'd have to be a little more advanced in our data, frankly, than basic Sentencing Guidelines Commission data.
But you could do that with the court administrator.
You could. I don't
know if they're going to give us.
But they're good. And I just want to, step aside and talk about, in my hat as the executive director of the Sentencing Guidelines Commission, we don't have unlimited research resources. And, we may need extra funding for that as well to try to get into some of that information. But I think we'd be missing out on a really important slice of this if we ignored the effect of not just the mandatory minimums in practice, but mandatory minimums as threatened. And I don't mean threatened in any negative sense, but just like, as an incentive to plead guilty, basically. I think we'd be overlooking something important. So anyway, I guess, and I will say my big thing is rationality, and I have some rationality questions there with the difference between intent and premeditation being not so large, and the difference between the sentence for intent and premeditation for murder being really enormous. I mean, that's the closest thing Minnesota has to the death penalty, and in fact, there's some Supreme Court case law that says, when you're talking about juveniles, essentially a life without release sentence is equivalent to death penalty for purposes of U.S. Supreme Court case law, which so if somebody's 18 instead of 17, they're getting something that's pretty darn close to the equivalent of a death penalty in Minnesota, at least as the Supreme Court has construed it. So I spent a long time on life without release. And then we have the first-degree murder in other cases. So what used to be the default and the majority were these first-degree murder not described above. That used to, before 2005, include premeditated murder. And that's where somebody would serve for at least 30 years. But it was an indeterminate sentence, so it was basically 30 years to life is how you got to do it. And that's really unusual that we have indeterminate sentencing in Minnesota, but that is a case where essentially it's up to the parole board how long the defendant actually serves. And I'm sorry if I'm misspeaking it, but when I say parole board, I'm sure there's a more technical term, but
Supervised release board.
Supervised release board. And then we have treason. We'll move on. Someday we'll see a treason case. All right. I read the elements, and I'm pretty sure rooting for the Packers qualifies as treason, but I'm not sure. It's a little vague to me. So then we have some criminal sexual conduct ones where there's life with possible release. I'm gonna second or third degree murder if there was a previous heinous crime sentence. Heinous crime list is very short. No sentences in scope. Bottom of this page, please. Okay. All right. So down at the bottom, we get to, and I'm happy to talk about any of these, but again, I think the question is, what do we want to spend our time on? And we should note that so far, I think we've seen only hard mandatory minimums. I think we've just seen no's in the column there. So we finally get to some numbers here where we talk about some of these. Well, there's a 10-year mandatory minimum for first-degree assault on basically a peace officer or other official, but it's usually a peace officer by deadly force. And there were 6 of those, so that's not inconsequential. And there's no. I mean, that's definitely a plea bargaining thing. I know I had one of these cases and I sat down with the police. I'm like, do you really want this guy to go away for 10 years? And they were like, no. So we pled to something else. I'm sure it was second-degree assault. So, so aggravated first-degree controlled substance crime. So that's a new crime from 2016. And it is a hard mandatory minimum. Basically, they have to go away for the guidelines grid time. And it's at least 86 months if they have no criminal history, but it could be longer than that. And we had 10 of those cases. It's pretty limited, so it has to be a large amount, and the next two boxes show those large amounts. So it's basically something that's in those next two boxes where you get at least 65 months. And then there has to be either a firearm that was used in the course of that crime or two aggravating factors. So can we move on, please, Don? Oh, you moved on. All right. I got to keep up with you.
Sorry.
No, that's fine. I'm looking at my own slide. I wish I could present this.
Oh, that was good.
You're good. You're good. I'm just behind. So yeah, so you can see those two boxes there. Those are the two offenses, which if you have the two aggravating factors or you have a firearm, it becomes the 86-month aggravated first degree. Otherwise, it has a 65-month mandatory minimum. And finally, we see if it's possession rather than sale, we see your first soft mandatory minimum, where the judge has the authorization to depart if the defendant has a pretty clean drug record, other than like fifth degrees. Okay, so can we move on just a little bit more? So committing a felony violent crime, finally we get to, no, that's not it. So, okay, possessing a firearm or ammunition. So this is the first 6 and 9/11 offense. We see a dramatically higher number of offenses there. I have the list of crimes of violence. So this is a lifetime look back period. So if you're ever in your life convicted of a felony crime of violence, you can never possess a firearm or ammunition, A, and B, if you do, it's a felony, and C, it's a felony with a 5-year mandatory minimum. And that mandatory may be hard, may be soft, depending on table 2. I'm not going to get into table 2 today. We don't have enough time. But I encourage you to read it, maybe read it from the bottom to the top and see if it makes sense to you. It fails my rationality test. It's very confusing. A, it's just plain confusing, but B, it doesn't make sense. And particularly what's hard and what's soft and what gets enhanced to a longer period of time. There was a bill in the last year that I thought was interesting to take Chapter 152 drug crimes off the crime of violence list. If you read the crime of violence list, it does stick out a little bit. It doesn't seem like it's necessarily all crimes of violence. The bill might have been written with a more nuanced touch. Maybe they could have left aggravated first degree controlled substance crime on there, but I thought that arguably was an improvement in rationality because what's the reason? And I don't know whether that's within the scope of this task force or not, but it definitely has that 5-year mandatory minimum. If it does have a 5-year mandatory minimum, maybe we could tone it down a little bit as far as what's considered a crime of violence and at least limit those to violent crimes. But I think that's something we need to talk about is what's the purpose of that offense? And then I guess I'll just, in the interest of time, I'm just going to stop here and talk about 6 and 9/11 in general. So not the possession of firearm or ammunition, but in general. So those involve committing a listed offense. So it's a pretty small list of offenses, and either you have to use a dangerous weapon other than a firearm, or you have to, and you get a shorter mandatory minimum for that, or you have to use or possess a firearm. So you could be committing this crime and not use the firearm at all. It could just be in your pocket. So an example would be if you're possessing drugs and you have a firearm on you, even if the drug possession didn't in any way help you, or wasn't aided by the possession of the firearm at all, that would invoke the mandatory minimum. All right, so I think in the interest of time, I'm going to stop here, but I guess the question for us to think about is what's within the scope of this group. Like, do we really want to look at all of these mandatory minimums? Do we want to focus our attention on some of the mandatory minimums? Do we want to look kind of behind the scenes a little bit? For example, was just talking about possession of firearm or ammunition by somebody who's ineligible. Do we want to like look at the underlying crime and say maybe that should be changed a little bit, and then I could see a mandatory minimum that would be appropriate for that, or maybe have two different levels of it. Same thing I would argue with predatory offender registration. It's another pretty big one that we didn't talk about. Maybe there are ways of violating the predatory offender registration statute that where it's appropriate to have a mandatory prison sentence, but maybe there are some ways where it's not.
Ashley raised her hand.
Yes, Ashley.
Nate, I was just going to talk or kind of say this exact same thing that you were just saying about the predatory offender registry, but I guess like I'm curious to see what types of like violations, because my understanding is sometimes it can be things like you're not updating your address in time, which I'm not saying that's not, like, I think someone should take that seriously when they're on it, but if it's not, reoffending or causing harm to another individual, like, I would be curious in kind of exploring what those violations are.
And this, there was a task force on predatory offender registration that met recently, and they made some recommendations, and some of it was sort of left unfinished. And I think this is one of the areas that was left unfinished. I think if I'm recalling it, I could be mistaken, that one of their recommendations was to have a phase 2 where they address this. I mean, there's nothing that would say that we couldn't be at phase 2. So maybe it would be an appropriate agenda item at some point, if this is something the commission's interested, or the task force is interested in, is looking at basically what did that task force learn, the predatory offender registration task force, and is that something that we could build on without having to redo everything? Take their Wilder generated report and read it and see if that's something that we could take a look at, because that's certainly not insignificant in terms of numbers, that the number of people who fit under that predatory offender registration statute.
Mr. Chair.
Yes.
I would also, and I apologize because I'm going to have to leave a little bit before we're finished here, but the one thing I would say is I think that we'll have the most impact if my vote is to focus on the offenses where people are mostly sentenced. So those high number, the high volume offenses or high volume mandatory minimums that you pointed out, to me seem like a logical point of departure for this work. And if we we're going to have to narrow the scope for the input phase as well, right? Because it's, and the data analysis, because it's going to be kind of impossible it might be harder to get or analyze all of the data for all of those offenses. And some of them have such small sentencing rates that they may not tell us anything useful. So my vote is for narrowing in on those offenses that have higher rates. And so I think that's everything on your bar, essentially, except maybe the other.
The other, basically. So.
Yeah.
So, okay. So you'd say drugs, predatory offender, and 6911.
Yeah.
Okay. How do other people feel about that?
I mean, I still think it's important to think, like, what is the goal of having a mandatory minimum sentence? And I think that's an important thing that the legislature has not articulated. Like, why are we doing this?
Mm-hmm.
If the purpose is to deter somebody from doing this through like a secondary deviance mechanism, then people have to know that these things exist, right, in a way that would affect their behavior. And if that's not the case with some of these, I think with the predatory registration thing, I think there's maybe more of a, like, you're clearly very much in the system, and people, versus some of these other, like, possession of a non-firearm when your accomplice as you know what I mean? Like some of these things are not clear to people. And I think that in order to affect behavior. So, ultimately, I think it is worth having a conversation about what is the utility of a mandatory minimum sentence from the state's perspective, right? Not as a strategy for prosecutors or defense judges or whatever, but just like, why are we doing this, right?
Yeah.
Because I think that speaks also to like first degree premeditated murder. Like if that's, if we're doing this because we think it's going to deter people, it didn't deter those 6, but it's, so I don't know.
Maybe that just means that the data collection is focused more on where there's more, but that doesn't mean that has to be the end of the discussion.
Yeah.
I don't know, maybe that's just a strategy for trying to get as much information as we can in a short period of time.
But I'll just say, I think one of the benefits of having a task force like this, I think this is good governance. I think it's a good idea to have people review policies from time to time, whatever those policies are. They could be internal office policies or statutes, but just review them on an iterative basis to say, is this still doing what we're trying to do? And that's not something that the legislature naturally does. And I think it's really wise of the legislature to create task forces like this. So it's basically they're putting it on us, I think, to do that thinking that really, getting exactly to what you're saying is what is the purpose of these mandatory minimums, and are these statutes doing it the right way? All right, so let's talk about meeting dates and if we're going to do public comment. So Don sent out a survey for.
I can show the results of that survey.
Okay. I will admit I just filled out the survey while we were meeting. Okay. Well.
So from the looks of it, of the 9 results that we had, the second Friday morning and the third Friday morning were the best times for the most people.
Well, you're all here on a Friday morning, so that it's a little selection bias, but we are required to meet at least monthly. I'm assuming, I guess, for no reason, but I'm assuming that monthly is a good time to meet. I mean, it gives us a little bit of time to sort of react and think about what we need to do for the next meeting and prepare for that. So I do appreciate monthly for that reason.
I'll just observe if it's the second Friday, that's about 2-3 weeks from now. So we would just get on our next meeting would be sooner than, a month.
Right.
So in that regard, I know there's a lot of sort of logistical stuff that has to get off the ground. And so maybe the third Friday sort of makes more sense just to give us an extra week to kind of get some of that other stuff going.
Okay. Any objections to making it the third Friday? Anybody who's like, well, I can't make it if it's the third Friday? Keeping in mind we can all beam in from wherever we are.
Yeah, this is Mark Osler, and I haven't been getting the emails. I didn't get the notice of this meeting in the agenda, so I need to be added to the list. And I don't think I got the survey on dates. If the third Friday is going to be October 17th, I'm not available that day.
Okay. Would you be available the second Friday?
Yes. The 10th.
All right. Well, I'm fine with doing it the second Friday then. I think the task force is small enough that we lose a seat. We don't have a lot of redundancy. I guess we do in the county attorneys, but otherwise no redundancy. So let's make it the second Friday then. Is this room available?
This room is available, yes.
All right. And then is there a way to get public comment? Let's see.
Yes, I will stop. What I will do is I will unmute all the attendees that are online. And if they have any comment, please state your name and then you can ask your question.
Don, can I suggest an alternative? So I did that one time and I don't know, you can get people flushing their toilets or whatever. I mean, people aren't necessarily tuned into the idea this is a two-way communication device when they're listening in. So rather than, do those folks have the ability to raise their hands? That's my question.
If they are attending on a computer, yes. If they're attending on a phone, it's not, I don't think they have that ability unless it's a smartphone.
I think
So-
everybody's either on a computer or a smartphone.
Yeah. So yeah, if someone wants to raise their hand, if they have public comment, I can unmute them then.
Oh, there we go. It worked. Or at least it worked for one person.
There you go, Jennifer.
This is Jennifer McClary. I am attending from Wilder Research. And I just wanted to let you know that we do have, just following up on that discussion about whether Wilder could contribute to data collection. We do have extensive experience with trauma-informed data collection with hard-to-reach populations, and would be happy to answer any questions that you have about how to gather data from stakeholders in ways that are appropriate and effective and comprehensive. And also, would just be happy to advise you on that too, in our capacity as facilitators.
Thank you, Jennifer. Don, I wonder if you could just pass that comment along to Assistant Commissioner Mitchell, since
I
she's the
can.
chair of the stakeholder input and she had to leave a little bit early.
Absolutely.
Appreciate that comment, Jennifer.
Yep, thank you.
Okay, if we've reached the end of our agenda and we've reached the end of our time, we've gone past the end of our time. So if I'm going to call for any objection to adjourn, if there's anybody who objects to adjourn, please speak up. Hearing no objection, this meeting is adjourned. Thank you all.
Good to meet you. One of those exact same socks.